Good afternoon. My name is Jim Ludwig, Major Gifts Officer at Vegas PBS, and I want to welcome you to our virtual Plan Giving Seminar presented to you by the Southern Nevada Public Television's Planned Giving Council. What a mouthful. In today's seminar, you will learn about guardianship, hospice care, and care providing. Our event today is sponsored by the Nathan Adelson Hospice Foundation. We normally host these seminars at our beautiful station located at 3050 East Flamingo Road. As we continue to observe social distancing guidelines, today we bring you all the information in a virtual format. In full disclosure, this is a recorded production. If you have a question, please type it in the chat box to your right of the screen. Please enjoy this brief recorded message from Caleen Johnson, the Executive Director of the Nathan Adelson Hospice Foundation, on the importance of the topics we will discuss today as we continue to observe proper social distancing.
Good afternoon. I'm Caleen Johnson, the Executive Director of the Nathan Adelson Hospice Foundation, which is the fundraising arm for the hospice services that do not receive reimbursement from Medicare or insurance. I am going to speak with you today about the importance of advanced care planning. And it may seem like advanced care planning has nothing to do with fundraising. Yet in the bigger picture, your decision to think about what you want for your end of life may help you decide to leave Vegas PBS or Nathan Adelson Hospice in your will, or even another important community organization. We want those decisions to be made ahead of time so no one is left without a plan. Just like you planned your career, your family, and your retirement, each of us will also have to face the end of our life's journey. Most of us think our spouse, our significant other, or our children will know what type of health care we want. Some may have discussed their wishes, but not written them down. It's important to, 1, have the conversations, 2, select a person to make those medical decisions in case you are not able to do so, and 3, have a written document for healthcare providers to understand your wishes. In hospice, we see families in disagreement every single day about what their loved one would have wanted at the end of their life. I promise you that written communications about your own wishes is a gift to those we will leave behind. I don't want my child to have to disrupt his future family in order to care for me. I don't want to bankrupt my spouse by continuing to treat me for an illness that will ultimately be my demise. And I don't want to be on life support while costing Medicare thousands of dollars a day. Of course, your wishes will be unique to you. Most people know the importance of making these decisions, yet we can all be procrastinators when the topic is difficult. You don't have to do everything at once, but at least take the first step. Thank you.
I want to thank the Nathan Adelson Hospice Foundation for sponsoring this very important seminar today. We have 3 experts in their field with you today: David Straus, Shannon Evans, and Deb Erdmann. But before we begin, here's a brief update from our General Manager, Thomas Axtell, on what Vegas PBS has been doing the past few months.
Thank you for joining today's Plan Giving Seminar. I'm Tom Axtell, General Manager, and I hope you and all who are near and dear to you are in good health. In response to the COVID-19 crisis, Vegas PBS changed program schedules, produced an amazing amount of content, expanded access to instructional web resources online for teachers and parents, secured approval to expand state-funded job training programs, and promoted the services offered by nonprofits, government, and emergency managers. We secured significant gifts from individuals to support some of these services. And even though 70% of our staff is working from home, they continue working very hard to serve our community. Anticipating online education this fall, we've launched a statewide website for teachers and parents with over 300,000 engaging educational modules for use in online instruction to support meaningful at-home learning. Vegas PBS is also running personal safety messages about hand washing, wearing masks, and social distancing. And in association with our fellow nonprofits, we're running TV spots highlighting where and how to access food, medical services, mental health, legal and financial assistance. We're running over 150 of these messages a week on all our channels. We're happy to say we've seen increased viewing of the PBS NewsHour, Frontline, and our vegaspbs.org website has added extensive materials on health information, as well as many links to local community, educational, and career training resources. Our program Nevada Week has distinguished itself with a series of COVID-19 programs covering topics and including guests that have been overlooked by many other media. To produce these programs, we had to purchase new equipment and software that allowed us to produce TV interviews with multiple guests who all were speaking from remote at-home locations. During the crash of 2008, PBS stations and Vegas PBS experienced a 20% decline in donated income. Happily, several major donors and board members have already stepped up to help sponsor these local services. And now we're offering sponsor packages for Homestrong, Learning from Home, STEAM Camp, and our 2020 election, as well as our new local history documentary, The Showgirl, a Las Vegas icon. We'd be happy to share more information on these opportunities with anyone who is interested. Well, this is our third online plan giving seminar. We believe it will be the norm in a wave of virtual events that are now required to engage audiences like you and connect with donors. We will eagerly anticipate learning from your feedback on what we can do to improve this experience. I want to thank Shannon, Deb, and David for their expertise on the topics we're going to cover today. And I also want to thank Nathan Adelson Hospice Foundation for being the sponsor of this seminar. So in conclusion, we're maintaining large audiences on TV, producing unique and original local content, delivering public services using new technologies, and partnering with dozens of other local organizations. All of this is laying a foundation for previously unimaginable services that are required in a society where people increasingly work from home and where distance education becomes the norm for schools, colleges, and professional education. So please take great pride in what we accomplish together with your donations. Tell everyone you know, and most importantly, keep yourself and your family safe. Thank you for joining us today.
Thank you so much, Tom, for these updates. As you can see, your public service media station has been very busy during these unprecedented times, trying to provide the community with much needed resources. I know personally the effect that Vegas PBS has had on our teachers, as my wife is a kindergarten through second grade deaf education teacher at a local CCSD school. And she is using ClassroomCast with her students and parents as part of the new distance learning model. This enables her to connect with her students and parents through closed caption as well as in multiple languages. Without further ado, we begin our seminar today. Our format will be a question and answering session, but before we begin, let's meet our experts today. Shannon Evans. Shannon received her bachelor's degree in business and economics from the University of Santa Barbara and her Juris Doctor from the University of San Diego School of Law. She was admitted to the California Bar in 1990 and the Nevada Bar in 1991. On a personal note, Shannon is a single mom with a teenage daughter. She has a ranch with horses, a donkey, chickens, and cats. Now it gives me great pleasure to welcome back David Straus. David is a native of Las Vegas and founder of the law offices of David A. Straus. The firm limits its practice to estate planning, charitable planning, asset protection, and trust administration. David has more than 29 years of experience in estate planning and asset protection. David received his Master's of Law in Entertainment and Media Law from Southwestern Law School in LA, his Master's of Law in Taxation from Golden Gate University in San Francisco, and his Juris Doctorate from Whittier College School of Law in LA. In addition, David has authored 5 books on estate planning and asset protection. On a personal note, David has a very impressive reef aquarium in his office. Please welcome back David Straus. Now I'd like to welcome Deb Erdmann to the program, Vice President Trust Officer of Peak Trust. Deb has over 20 years of experience in the financial services industry, specializes in qualified plans, self-directed IRAs, and pension administration. She earned her Bachelor of Science degree in Management Information Systems from Buena Vista University in Storm Lake, Iowa. Her professional accreditations include QKA, Qualified Pension Administrator, and CISP, Certified IRA Services Professional. She also holds her Series 7, 63, 65 securities licenses. On a personal note, Deb is a married mom of 2 sons. One is a geological engineer, and one is a newly graduated from UNR with a finance degree. She's asking, is anyone hiring? She also states that one of her sons can find a good spot to bury her, and the other one can figure out how to pay for it. Now let's get this show on the road. Question number 1 for the panel here. What is guardianship, and what is the current state of guardianship in Nevada?
Great question, Jim.
Thank you.
Deb and David and I have worked together for the same families and clients for many years in Las Vegas, so we've all worked together and we're familiar with the process. I'm going to talk about guardianship and when it's necessary, and then we'll go to some other topics. So guardianship, there's 2 kinds. One is guardianship of a minor, someone under 18. And the other is guardianship of an adult. Usually in our situation, that's someone who's our parents or grandparents and they're getting older and they need a little help. There are ways to avoid guardianship and make it easier that David and Deb are going to talk about, but I'm going to talk about the court process. Guardianship has to be a process by where you petition to the court to have the court appoint someone to be the person who controls the person's estate, which is their money, or where they live, how they live, their living accoutrements, which is their person. So you have guardianship of the person and the estate. Sometimes people do both at once. Sometimes they just need the estate, so it depends. Let's talk about the general guardianship process in Nevada. We all know this. It had a big revamp in 2019, which we've all seen on TV a lot of times. There was a lot of abuse of the process, and some of the process now has been streamlined and is a little bit easier. It still takes some certain steps. You have to usually use an attorney, and it's not perfectly easy. It takes time. Usually it takes a couple months to get someone appointed as the guardian. So one thing I like to do is in a person's, and we're going to talk about this later, in a person's will or the power of attorneys, I like to appoint who would be the guardian of their person and who would be the guardian of their finances and their estate, so they can pick who they would have preferred in the beginning before they become disabled, and that helps a lot. Even though a will means you're deceased, you can appoint who your guardian would be in your will. So the next step is you file a petition and you go to court, and the court appoints someone of the guardian, and usually it's a pretty smooth process. There can be disagreements between family members as to who wants to be the guardian, and we've all been there, and that's kind of ugly, but we try to avoid it and have someone meet their wishes and pick the person they wanted to be their guardian. So we have to be careful about financial abuse by anyone in the family or a professional. So the court has a rule where they require an accounting once a year of whoever the guardian is of the money in the estate, and they handle their finances and explain to the court what they've been spending the person's money on. And that's fairly carefully monitored. You really can't get away with a lot of wrong spending by the son or someone, so, or the girlfriend or whoever. So I think that's a process that's kind of arduous, but it's careful, and it tries to ensure that the person's money is being properly spent and they're in a proper living environment and not just being dumped in a home and not being taken care of. So I think the process itself is not egregiously difficult or negative even, but there are lots of ways to avoid it, and that's the thing we're going to talk about next.
Yes, let's take it from there from what Shannon said. What are some ways to avoid guardianship?
Yeah, there are several ways to avoid a guardianship. I haven't done many in my career, maybe one or two, because my clients do a lot of planning around guardianships. Number one is to do a durable power of attorney for health care, where you can name the guardian of your person inside the document, and basically you can avoid a guardianship that way. So if you execute this document, you can state who you want to step in, if you can't make decisions for yourself with alternates, but you also give guidelines of how you want to be cared for, how you want to stay in your own home. And in October 1st of 2019, we passed a new law in connection with the durable powers of attorney for health and for property, which we'll get into in a second, which deal with staying in your home or not staying in your home. And under the new form, if you want to be able to stay in your own home, as long as it's safe, you can do that and basically not have to go to court and have a guardian appointed. If you, it's very unclear right now with the new law whether you have to initial the box or not, but I know in the form itself you either initial a box that says you'd like to stay in your own home unless it's not safe, and if you initial the box, as long as they discuss it with you, you can be placed into a facility without a guardianship. The other box on this new form, which just became effective October 1st of 2019, states that if you initial this box, that you will want to stay in your own home at all cost and have to have a guardianship in order to be placed outside of your home. And that's in the durable powers of attorney for health and for property, both of those provisions. In addition, as Shannon brought up, another way to avoid it is the guardianship of your estate is doing a durable power of attorney for property. And that's where you appoint someone in a document. So if you become mentally disabled, you don't have to go to court and do a guardianship over the person, but you have to satisfy what you initial inside that. So some people, when they do durable powers of attorney for property, state they only become effective if two licensed physicians state you can't manage your own personal affairs, or they become effective right away and are durable and good until the day you die. And those same two provisions about staying in your own home are in the brand new form. So I think it's really important for the viewers, Jim, to think about if they did their documents prior to October of 2019, they should visit their attorneys or visit an attorney and have those documents updated so you comply with statute. The third thing and last thing is that if you do a funded revocable living trust, meaning you do a trust and you put your assets in the name of the trust while you're alive, if you become mentally disabled, the person you name as a successor trustee does not have to do a guardianship of the estate. They would step in by, let's say, two licensed physicians or disability panel, depending on how you define incapacity in your document, and you avoid a guardianship in that regard regarding those assets.
Excellent. Thank you, David. And I just want to remind the viewers, we're doing a different format. Both Deb, David, and Shannon, once this recorded message is completed, will be back in a virtual setting and will answer your questions that you put in the chat box. So please, if you have any questions, please put them in the chat box, and we'll continue with our program here.
And one point really quick.
Sure.
Jim,
go ahead, Deb.
David, could you clarify so that when they changed the law back in October 2019 on the, specifically the power of attorney, that's only for the state of Nevada?
That's right. It's state by state, Deb. Good point.
Only because I know a lot of our viewers maybe have multiple residents.
Yes.
And so that's an issue.
I think one really good point that David brought up that Deb had experience in is who you choose as a trustee of your trust is a big deal. And if you make a mistake and become incapacitated, it can be changed, but it's hard. Why don't you talk about some of your experiences in that, Deb?
Yeah.
Oh, thanks, Shannon. That's a good point, because what I do is I work for a trust administration firm. So we act as the professional trustee. So if you're not able to act, you don't have anybody else to step in your shoes, you can hire a professional company to step in and take over that role. So a lot of people think that with a trust, you have to pass away in order for the successor trustee to step in. In this case, as we're talking about, disability is something, or not disability.
Incapacity.
Incapacitation is a reason where we would have to step up and start acting as trustee. So in fact, I'm dealing with that kind of on a personal level right now, where I've got a family member that is in the process of most likely going to be deemed incapacitated. The trust does state you have to have two physicians sign a letter saying that that is what has happened. And in that case, he will no longer be able to act as trustee. And so in that case, the successor trustee is going to have to take over and act for all of his financial aspects. And one point as we proceed, I want to make it clear, and it'll probably come up again, as a professional trustee as we go through and talk about guardianships, because as David pointed out, there's there's powers of attorney over the person, and there's a power of attorney over their finances. Now, as a professional trustee, we can't act over the person. We can only act over the finances.
This is for the entire panel here. What type of guardianships are available? I know we kind of touched on that a little bit, but if we could just get a little more in depth on that.
I can talk about that. Well,
Okay.
like we said, there's guardianships of minors and guardianships of adults. So I'll give an example of a minor, because that doesn't happen that often. I had a client who had a son born with Down syndrome, and he's lovely. I've known him since he was 8, and now he's like almost 28, believe it or not. And you don't need a guardian over someone's estate when they're incapacitated and they're a minor, because you're the parent. Once he got over 18, though, he had some funds from his deceased father in a trust, and the trust did not have to go into guardianship at all. That's why they set it up correctly. His father had a life insurance policy that paid to a trust, and everything was smooth. He had quite a bit of money, enough for his life. But he had a little bit of money from a car accident. And that is not in a trust. It wasn't a lot compared to what he had in his trust, but because there was money from a car accident, and because he was a minor, we had to go to court and have the court do an accounting and make sure that the money was spent properly for him. And ultimately it worked out just fine, but that was one example. Another example is someone who's older, maybe getting a little dementia, and I think some of you will have some stories about this. The key time is when they start getting a little bit fuzzy, people take abuse of them before they get full-blown incapacitated and dementia, and that's the time where you have to appoint a proper guardian that's going to take good care of the person, and there's usually a lot of fighting with the family. So I like it when the person has said ahead of time who they want to be the guardian. One thing before we get into some stories that I think is really important, until the new rules last year, you had to have a Nevada co-guardian if your people were out of state. So let's say I wanted my daughter to be my guardian and she lives in California. Well, you had to pay a Nevada co-guardian, and that caused some problems. So they changed the rules now. As long as you designated it in a document and you have a resident agent, like a person to take service of process in case your daughter has to receive a notice from the court or something, it's fine to have someone out of state, your kids or whoever you want, to be the guardian. But be careful who you pick. It's a big deal. So I'm sure you have some stories about that, David.
Yes. You know, Shannon brought up a great point. We did change that statute, and it's not required to have the co-guardian in Nevada, which is a really big deal now. It saves a lot of clients, and that's why proper planning ahead of time is critical. And what I consider someone becoming disabled or incapacitated while they're alive is called a living probate. It's not like a death probate where you have to file your will and have your assets passed, but become disabled. And hundreds of % more of the people become disabled now and don't just die right away anymore. I mean, years ago, you get a cavity and people died. It's not happening anymore, and hundreds of % more are living longer. And it happened to Groucho Marx. I mean, Groucho Marx became mentally disabled while he was alive. His live-in housekeeper girlfriend went to court and was appointed to take care of his estate. Several months later, she was allegedly gouging the estate, and Groucho's grandson and I think Bank of America went to court to get appointed. And they had a mini trial where they wheeled Groucho in and out of court every day. All the movie stars testified, and Groucho knew what was happening. He had a tear in his eye every day, and basically the grandson and I think the bank were appointed, and he died a few months later. If he had done a proper plan and did a trust and funded his trust and did proper powers of attorney for health and property, he would have avoided that living probate, and I find that to be really important.
I have one suggestion that I know we've seen. Let's say you set up a trust correctly and you identified the first choice for trustee and the second choice, which is normal. And let's say your son was the first choice and he was in an accident and can't be the trustee anymore. And your second choice was your daughter, who never was quite as successful financially and maybe wasn't so good with money. Let's say I become disabled and my trustee starts abusing my funds and buying themselves cars and going on trips. Oh, that never happens, does it? So just because the trust is already in place doesn't mean you can't change it. You have to go to court and have them supervise a change, but you can always petition if someone's abusing the trust. Talk about that a little bit.
Yeah, there's a provision, substituted action in Nevada, where you can go to court, go to guardianship court, and have a trust funded or changed or whatever according to the way that the judge deems in the best interests of the person. And we do that. And sometimes we'll even go to court ahead of time and have estate plans approved by a judge, give everyone notice, and this way if someone passes away, it makes it easier. And Jim's going to bring up a little later about abuses, about about people making gifts and void transfers to caretakers or people materially participating in the design of the estate or paying for the plan, where in Nevada, you need to have an independent lawyer sign off like California does, or else those transfers are deemed void ab initio from the beginning, and unless the judge and clear and convincing evidence determines otherwise, those transfers are not allowed. And I think it's critical to discuss that, which we're going to do later, I think.
That's actually my next question. Thank you for leading into it. It's how can we protect them against financial abuse? You hear so much of it out there. I've heard it's in the billions of dollars where people are abusing our elders and those kind of things. Do we have any suggestions on that or stories?
Yeah. From a trust standpoint, I think, to David's point, is proper planning.
Okay.
Is if they have all of their estate plan in place, they have their living trust, they have their will, they have their powers of attorney all lined up, that they know where those assets are, and they have them controlled by the person that drafted the trust, right? So while they're alive, they control the trust. And who they name as successor, to Shannon's point, they like to name their children. They think, I'll start with my oldest, I'll go to the next. Well, they aren't always, I know you love them, but they aren't always fiscally responsible. And so that is where it really, you need to take a step back and think about who do you want to step into your shoes. And I'm not advocating 100% of the time that having a professional trustee step in, but there are a lot of cases where that is what you need to do, is have someone who's completely disinterested. They're going to come in with no emotional baggage, and they're going to follow your wishes to the letter, exactly how you've listed it in your trust. And just I wanted to make one more point back to what we talked about earlier, is really one of the big ways you can avoid some of these abuses is as you develop your trust and you have your wits about you and your whole family is communicating, sit down with your family, show them where your trust document is, show them where your will is, show them where your powers of attorney are. Make sure that you've given them all the information they need, because one day somebody's gonna have to step up and take control, because for some reason you're not going to be able to. Because we have a situation now that we're dealing with where one of the siblings came in and wanted to have a new power of attorney put in place. But we pulled the documents because we had all the estate plan documents, and there is a power of attorney that was drafted 5 years ago that was perfectly legal. It had been notarized. It was what was needed. But one of the siblings didn't think, because this sibling happened to be farther down the chain, wanted to be able to step in and usurp everybody else. So their idea was, well, let's just go get a new one. Well, Dad wasn't in the mental capacity to do so. So luckily one of the other siblings stepped in and said, no, we already have the documents and here they are.
I think another situation that happens all the time is someone's a little bit older and they're actually making a good decision and they want to replace someone on a power of attorney, but there's always a big fight between the kids.
Right.
So sometimes when they're going to do that, I have them get a competency letter from their doctor, which doesn't mean they can balance their checkbook. It means they understand what they're asking for, and that letter is in the file and it will stand up. What do you think about that, David?
I think it's great, and our power of attorney statute requires if someone's in a residential facility, you must have a certificate of competency or else the power of attorney is not valid. But in addition, this elder abuse, because I got tricked about 10 years ago by a caretaker, and if anyone's ever made, and we changed it, it was only transfer instruments on death, that if you gave to a caretaker, to a dependent adult, to a caretaker who was compensated, or they materially participated in the design or paid for it, it must be signed off by an independent attorney or it's void. They changed the statute several years ago, and that applies on death and for gifts while you're alive less than $3,000 in one annual year. So as a trustee also, Deb, it's important when you take over, if you go through and check the checking account and savings accounts and transfer documents, if someone gave something to someone who is not a real natural object of their bounty within intestate succession stance, that is a void gift. And as a trustee, you have a duty to probably investigate that and make sure. That elder abuse stuff, I'm really fed up, and I'm glad they did it, because I got tricked on a case that went to criminal. They were indicted by the grand jury, and I found it just because people who are elderly people count on, especially caretakers who are doing some really nice services for them, and they feel obligated to have to give to them, because sometimes the caretakers say, well, I'm not going to take care of you if you don't leave me something. And I'm not saying it happens in every case, but if they do it, you better have an independent lawyer sign off, or it is void in and pursuant to our Nevada statutes ab initio, and it can be set aside, and it can become pretty big litigation. I know Alice Denton, who's a local lawyer in town here, whose husband is a judge, takes those cases, and she's really solid with following through on that stuff.
I would say you've all seen this with people you know. As people are getting older, us baby boomers, we're getting older, there's a fine line between a caretaker and a girlfriend or a boyfriend.
Right.
It's a very fine line. And so sometimes the person says, I'm the girlfriend, and I say, well, are you paid? Then you're a caretaker.
Yeah.
So I'm just saying, you want your parents to be happy, or your grandparents, you want everyone to be well cared for, but you have to be careful about that.
But it's not even a paid caretaker. It's also someone who materially participates. And it used to be active participation. So if they drove them to your office, that may be one of the indications. But they changed that in the statute a few years ago to be materially participate in the design of the case or pay for the documents. So we always want to be careful and double check those. And in the abundance of caution, as an attorney, you should always have an independent lawyer go through it and do the affidavit of independent attorney.
One thing that I think also could come up all the time that we do in our practices, let's say you have a trust in place and your parents, one dies and one's incapacitated. The trust is now pretty much irrevocable. Well, there's something in a lot of states, including Nevada, called decanting. You know, if anybody drinks wine, which I do once in a while, you pour the wine from the bottle into the holder and it makes it breathe, and it's called decanting. Well, now you can fix an irrevocable trust with pouring new language into it as long as you meet certain requirements. So talk about that.
Yeah, sorry, David.
No,
we see that quite a bit, because a lot of people think that once a trust, like Shannon said, if it's considered irrevocable, meaning you can't change it, it's done, it's locked in, and that is not necessarily the case, because we get involved in cases like that where there's an irrevocable trust. The beneficiaries come to us because there's some provisions in there that are not clear, they're not clean, subject to some very specific things, meaning like you can't remove beneficiaries is one of the stipulations when you decant. But there's a lot of other, especially in the state of Nevada, our decanting statutes are very liberal compared to a lot of the other states, and not every state does have a decanting statute.
Yeah.
I can give a suggestion, one that worked really well recently. Let's say the person had 3 children that are all adults, and they're all pretty normal. One of them was on SSI. If any beneficiaries on SSI, which is government income support for you, or Medicaid, they cannot inherit money from a trust, or it might be taken by the government entity who paid for them from all their life. So the person was already older. We couldn't change the trust anymore because they lacked competency, but their son was on SSI. And so we decanted the trust so that that person's share was not outright to him. It was held in trust and would be paid for by the trustee. That's when we appointed a professional trustee to meet the SSI needs, and it worked out perfectly. And it wasn't that expensive, and it was pretty easy. No court.
Yeah. Our decanting statute, is it a violation of the impairment of contract clause? My son, who's in law school, thinks it's a very unfair statute because you're changing what the trust maker's intent kind of was. But when you give a trustee the right kind of discretion in a trust, they do have the ability to decant. Always do a notice of proposed action, even though you don't have to, or go to court and get approval. The second thing is what I like in my document, Shannon, that I do in every trust I've done probably for about 15 years, is put in springing special needs provisions. So if you do need those provisions, they're in your document. It's almost like you pack a jacket, you go out of town, you don't know if you need it or not, but springing special needs provisions should be in most documents, so you don't have to decant, and just in case you need the governmental aid, you can always have the trustee put it into a springing special needs trust. So I try to include those provisions.
And we appreciate that, David.
Well, here's another thing that's interesting about guardianships. A trust, the person can live anywhere. It doesn't matter. They set up the trust here and they move to Arizona, or they move to California. Guardianships, if the person moves permanently, you have to register the guardianship in that state and change the guardianship. If it's a temporary living facility place, they're not necessarily becoming a resident of Arizona or California. You don't have to change it. But if they're permanently moving to a different state, you got to change the guardianship. And that takes another court proceeding and another money, and it takes more time. So one other thing that happens all the time, and this is dear to my heart and to ours, a lot of people become incapacitated and they have pets. What do you do with the pets? It's a big deal, and people care a lot about their pets.
Especially you, Shannon, with all
I
those that you
care
have.
so much. So
Actually, I have almost as many as you.
I have more pets than most people in this town. But I think that the main thing to know is our sponsor, Nathan Adelson, if a person's in the hospice care, which is fairly far along the line, they have a system where they'll help take care of the pets temporarily when the person's in their facility. And I think that's really special.
Yeah, no, it's great. And I think Safe Nest has Noah's house or Noah's home here, and that allows certain people to be able to bring their animals when they're kind of getting out of their home, escaping their home.
Right. They wouldn't let me because I have a mule and a donkey, but they would let you bring a cat or a dog or something normal.
So I could bring my 5 cats and 2 dogs?
You might be a little over the edge.
I have a wife who can't say no to a rescued animal.
Oh.
I know the feeling.
Yes. You answered a lot of the questions that we were going to go through, but there's one that really sticks out to me. Is there a difference between a care provider and guardianship?
Well, a care provider is a person, and this is a guardianship care provider of the person or estate. That's the person. They've actually been appointed by the court, and there's an order, and there's something called letters of guardianship that gives that person the right to make decisions for the person. A care provider, though, without guardianship, can just be someone hired by the family or the trust to take care of someone. So that's an easier thing. The guardianship one, you actually have letters of guardianship, which give you authority legally. Right? Does that make sense?
Yeah, I would agree with that. I mean, that's what I thought when I saw that question, is it's just the one who takes care of the person versus the person appointed by the court to be in the best interests of the ward to be able to do those things.
Right. Usually the court doesn't appoint a paid care person to be the guardian of the estate. They appoint a family member and they hire the caretaker. That's the more normal route.
Kind of shifting gears a little bit. A lot of times out here we have grandparents who are now taking care of minors because the parents are not able to do that. Can we speak a little bit about that? What about grandparents who are taking care of minors?
Mine helped my daughter so many times when she was a baby and I was working. They're critical to the whole system. I think one thing that's really easy, you can have a temporary limited power of attorney, letting a caretaker grandparent make decisions at school or medical, even if you go on vacation, which no one's going now, but if you did go on vacation, or letting the caretaker, it was usually a relative, take care of the kids with a power of attorney. And that's an inexpensive, quick document.
Yeah, I think by statute you can appoint someone temporarily to allow them to do those kind of things. And it's important to plan ahead, as Deb and Shannon have said. It's key. And if you plan ahead, you have less issues. If not, you'll end up in court and just
Costs a lot of money.
Grandparents are key to life. We really need them.
Are there any changes with the recent pandemic going on or anything like that in guardianship, or anything that you would like to add or suggest for what's going on?
The guardianship court is a lot of times online now or by phone, and you can file documents. And the other thing that I'm doing, that probably you are too, is there's now a system for a virtual notary, which is kind of different, and we've never used it until this year. What do you think about that?
I've done the electronic notary. You have to register, and the custody of doing the process is very cumbersome. But I did one on a will for someone even in California, because our statute in Nevada is so great with virtual notary that I could notarize someone in another country as long as it applies to something in Nevada. It's amazing.
I didn't know that.
In Israel even, yes, they said you can.
I learned something new.
Yeah.
Excellent.
I've only done it in the state.
Yeah, I've only done it, well, I did it for a document in California.
Interesting.
But I couldn't believe they said as long as you do your testing and everything here, Nevada says that will be valid in a foreign country even. I was shocked.
And I'm hopeful that will continue for people that need us to notary firm or after the pandemic. I mean,
Yeah,
why
you
not?
know what's amazing is our statutes are so ahead of other states. We were one of the first electronic will statutes in the country, and now all the other states are following us. And we have trust electronic, we have wills electronic, they mention it in the powers of attorney. I couldn't believe how the breadth of the law in Nevada, how far advanced we are. And usually we're copying every other state, but Nevada's pretty much on that.
And just one point on that notary, Jim, just to let the viewers know, is that it's even, you can't go to just any notary. The notary actually has to have a special license over and above, like your regular notary, like in person, but they have to take another test and they have to get another license. So just FYI.
So you can't go to the UPS store notary. You have to go to a...
Well, unless they've got the special certification.
Gotcha.
And I did do it. I'm an electronic notary and one of my assistants.
There you go.
Well, I wanted
All right.
to know about it, but also I think the document in a foreign country has to relate to the U.S. I think that's the key with the electronic notary out of the country. But we did it, and we went through the process, and it was a nightmare, but you know, we thought we'd have to do it. And
We're getting close to running out of time. Is there anything that any of you three would like to add to anything that we've talked about today?
I have one suggestion.
Sure.
Over time, as your children hopefully mature and become responsible people, you can change your documents. So when you're younger, you appoint someone like your brother or your mom, and as they age, you can bring them up to power or not, depending how they turn out. But remember to update your stuff every 4 or 5 years to just make sure you're up to date with your family. Divorces, things happen.
I concur with Shannon. It's like buying a car. You buy a new car every 5 to 10 years, you tune your car up, and people think, well, I did my estate planning 10, 15, 5 years ago. Well, this car that we build that holds everything you've worked so hard for needs to be tuned up. And it's not unreasonable to spend a little bit of financial time and your time and energy updating this car that holds everything you've ever worked so hard for, even more than the automobile you tune up every few years. So.
Yes. And the only thing I just want to reiterate one more time is please communicate to your family members and anybody that you've listed in your trust. Granted, we get to be the good or bad person to communicate that, but the more you communicate up front, the smoother it will be and the happier your family will be.
Good advice.
Great point.
Excellent.
Great point.
Well, I can't thank you guys enough. We are running out of time today. I want to let the viewers know we're using this new format, and we're really excited about it. So please go into the chat room, which is to the right of your screen. Type in any question that you have, and once this recording is finished, we will have David, Shannon, and Deb live, and I will be facilitating your questions to them, and we will continue this process together. I just can't thank Deb, David, and Shannon enough. We hope you enjoyed this seminar. Our next seminar is going to take place in September. The topic is going to be healthcare risk and all you need to know about Medicare and Medicaid, a topic near and dear to my heart when I was working with my late father, and I was helping him out with a bunch of issues that he had. This is a seminar you do not want to miss. And as usual, in the next few days, you're going to be receiving a survey on how this seminar was. We really appreciate your feedback on this. Everything from I was able to log in, I wasn't able to log in, or any topics that you would like for us to bring up in future seminars. So thank you so much for attending, and please stay safe and healthy, and have a great day.